Good day, everyone. Welcome to The Real Truth. I'm Tommy Spina, and today's guest is Federal Judge William Pryor. Judge Pryor, welcome to our show.
Thank you. It's great to be with you, Tommy.
I appreciate you reaching out to me and offering to participate in this podcast, particularly in the area that concerns me the most. But we have listeners all over the world. So if you don't mind, take a few minutes and explain how you got to the position you're currently in with the 11th Circuit Court of Appeals.
Oh, sure. Well, the short answer to that is President George W. Bush nominated me to the position of circuit judge on the U.S. Court of Appeals for the 11th Circuit in 2003. And my nomination, after a lot of fighting in the United States Senate.
See, nothing has changed.
That's right. Nothing has changed. Was confirmed in 2005. Along the way, the President Bush gave me what is known as a recess appointment in 2004. So I actually entered on duty on the 11th Circuit in February of 2004 during the President's Day recess. And then my nomination was confirmed for what my wife reminds me is a term of good behavior. Some people call it a lifetime appointment, but technically it's a term of good behavior under the Constitution in June of 2005. At the time, I was serving as the Attorney General of Alabama. I had been reelected to that position in November of 2002. I was first elected to it in 1998 after having been appointed by the governor of Alabama to finish the term of the previous Attorney General, Jeff Sessions. So I started as an appointee to that position before my election in 1998. So that's kind of how I got to the position. I started practicing law, as you know, in Birmingham as a young lawyer in 1988 after I had finished a clerkship with Judge John Minor Wisdom on the U.S. Court of Appeals for the Fifth Circuit in New Orleans. Finished following my graduation from law school at Tulane in 1987.
Well, that's quite an interesting trek there, but it seems to have been unidirectional in terms of the perspective that you will share with us today from a middle of the road sort of position, as opposed to what I do, which is defend people. And I've never prosecuted anyone, but and just never felt that was my calling. I didn't really feel that criminal defense was my calling, but it seemed to have found its way to me after a period of time. You mentioned something in passing when we opened about nothing has changed. I've said this before on this podcast, but while I was doing the TV portion of my media career, I guess, side gig, and as it was coming to a close, I went back and read the Declaration of Independence, and it really hit me in the head that, in fact, there are many similarities with what's going on in our government as we speak and what was going on in 1776 when we were trying to become an independent nation. The things that are going on are very similar to me. Do you share that belief in some regards?
Well, I think that the challenges of constitutionalism are ancient and recurring. And many of the things that the founding generation were arguing about, not only with the king and parliament, but among themselves, are ideas that we still debate about today.
except with different fervor, I suppose, or perhaps not. I don't know. I wasn't around back then, but
I don't know. It seems to have a lot of fervor these days, and it certainly did then. At least it doesn't appear that we're on the verge of war.
But are we on the verge of losing that which we fought so hard, not we as in our generation, but as in the generation of the people that fled England to start the United States of America?
Well, we should never think that that our liberties are secure, that constitutionalism is secure. It's always an ongoing project that we have to recommit ourselves to carrying on. And I'm not one who thinks that the future is a given. I think we have to re-educate our fellow citizens about what is a good and just government, why we revere the Constitution and take an oath to support and defend it, and we should take that mantle up, every day, every year.
And so it's an ongoing proposition, and you appear to me to have studied the Constitution and the writing of it and what all went into the writing of it. But there's some that say we have a Supreme Court in place now that strays from the rule of law, as I like to call it. But even when I say that, it is exactly what you said, ever changing, I suppose, or at least evolving, for lack of a better word.
I think we have a Supreme Court that is really as talented a court as we've ever had. I mean, I know all 9 justices. They're all very smart, all very talented, I believe, all very committed to the Constitution. They have some profound disagreements among them about some constitutional guarantees and how the Constitution ought to be interpreted. But I think sometimes we make more of their disagreements than we should. In most years, at least half, if not more than half, of the decisions of the Supreme Court are unanimous. When they're divided, the court does not always follow along the lines that we think about in terms of philosophical differences. There are, high-profile cases where the court may be divided along those lines, but really those are a minority of the decisions. It is that is a very serious court that its work is transparent. We can read their opinions and see for ourselves the strength of their arguments and make our judgments accordingly. But I, for one, have a lot of respect for that court. And I think, the way it's changed in my lifetime, I think the court is more committed than it's ever been in my lifetime to the idea that the Constitution is a written law and ought to be interpreted in a manner that ensures that we are being faithful to what the words of the Constitution meant at the time they were adopted. And of course, that a lot of the Constitution was adopted in 1789 and 1791, but a lot of the Constitution too is more modern, particularly the 14th Amendment, adopted after the Civil War. And that means we have to make sure that we're being faithful to what the meaning of that amendment was at the time that it was adopted. So There's a debate about that among lawyers and law professors and judges, but it's hard for me to see that as anything other than a serious commitment to the rule of law.
Well, clearly, and in retrospect, from a practical standpoint, it was written, intended to be amended, I believe. Do you find that to be an accurate statement based on your...
Oh, absolutely. That's what the Constitution itself provides for the amendment process in Article 5.
So some would say, and I think the media should take a hit from my perspective on how they pitch what the Supreme Court does. And I think part of the problem with the lack of understanding of some of those rulings that are outside of the mainstream rulings, as you say, most of their opinions are 9-0 decisions, but the ones that get the most attentions are the ones that are 5-4 decisions or even less. But the media seems to focus on that and pitch it to the audience that they're trying to sell to. So they're sort of marketing what they think someone will buy as opposed to just reporting it factually as it is. And that bothers me.
I think a lot of times the media focuses on what it regards as the politics of the decisions. I think if you were to, hear an oral argument at the Supreme Court, you wouldn't hear much in the way of politics in the courtroom. You would hear a lot of lawyers debating really technical kinds of legal questions, and I think that does get lost in the media coverage when the news media will report the bottom line result of a decision as opposed to the reasoning behind it and what the disagreements were on the court about that reasoning. Some journalists are a lot better than others in this respect. There's an Alabama native who covers the Supreme Court in Washington, D.C. for CBS News named Jan Crawford. I don't know if you know Jan, but she graduated from the University of Alabama, where she was an editor of the Crimson White. But then when she went to law school at the University of Chicago and actually practiced law for a while before she became a Supreme Court reporter. And she's terrific in how she reports about the court. She's not one of those who focuses on, who the appointing presidents of the judges were, but focuses really on what the legal dispute is about, what the reasoning is about, and there are others like her, but I think too many in the journalism profession who report on the court, they report on it like it's a horse race, like it's almost like it's a political race.
Right. Well, I have said sometimes that I feel in this climate that we're living in, that sometimes it seems like the press is almost becoming a fourth branch of government. And we don't want that to happen. I don't think.
Well, the thing about it is we had a vibrant free press, in many ways a very divided and partisan press at the founding. When the First Amendment was adopted, and that guaranteed, that secured the freedom of the press. And I don't know that what we see today in the divisions of the press and the partisanship sometimes of the press is meaningful way different from what you saw back then. There was a lot more anonymous writing in the press back then. You look at how many of our founding fathers were writing about the political disputes of the day anonymously, and it's remarkable to see that. But
well, you could do that back then.
You can look at the cartoons of Abraham Lincoln in the Civil War and the way he was portrayed in the press, and the press has been tough, sometimes mean, sometimes you could say unfair, but that's come with the freedom of the press, I think, probably from the beginning.
Well, and I wanted to talk about that. Obviously, in the 1789 time frame, there's a reason they put the First Amendment in there. They wanted the press to be somewhat of a watchdog, I suppose. You have studied the Constitution historically. Is that what was going on back in the day, which caused them to want to put that in place?
Sure, I think they absolutely wanted the press to help shed sunlight on the operations of the government. They were committed to limiting the power of the government. That's the reason they divided the powers of the government into three branches and into the really unique experiment of federalism, dividing federal and state sovereignty. That was a true American contribution to political science, all toward the end of limiting government, and no doubt among the liberties that they were securing with the Bill of Rights soon afterward was the freedom of the press and the freedom of speech, the free exercise of religion, all of which they thought served in a sense as checks on the power of government.
Well, do you believe that when certain, I'm speaking primarily of Sinclair Broadcast Group, that has required TV stations around the country and probably around the world to report messages that were written by someone up high and require the local news reporter to run that story identically in every station that they serve, that there's something wrong with that when they do that sort of centralized messaging?
Well, we certainly don't want a state-run media and a state control of media. But I think we're pretty far from that, particularly in the information age that we live in. So many people get their news, their primary news source is social media,
which has no guardrails.
No guardrails at all. But you have to view it as free.
But we have to, I call this show The Real Truth. Where is it? It's like I want to say it's out there somewhere. And I believe that in my heart. And I do believe in our system. And I do believe in the checks and balances and the three branches of government. I just want to keep them. That's all I want to do. And I find...
Well, I agree with that. I want to keep them too.
So you spoke once at Notre Dame about the historical judgment of history, I think you referred to it as.
Yes. Yeah.
Isn't that sort of what we're living in right now? I mean, we look back to find out where we're going to go forward. Yeah.
Well, what I spoke about at Notre Dame was that too often in our age, we ask, well, how will history judge something? And us, my point was that history's not a person. History's not a judge. When a judge or any public official makes a decision today, what should matter, what history tells us, future or past generations thought should matter, is the oath of office that we take. We take oaths to support and defend the Constitution and laws of the United States. That should be the measure of accountability, not some kind of speculation about what unborn generations are going to think of us, which frankly I have no way of foretelling, even if I were interested in doing it.
No.
What really matters is in the here and now is what does the law require of me, and am I being faithful to that oath of office? That's what the generations who brought us to this point and who gave us the constitutional republic that we have thought would matter, and I think that's what should still matter to us today.
Well, at the many people may not know the three layers of Article 3 judges. I suppose it's a simple way of saying it. The district court level, your level, which is the circuit court level, and then the ultimate Supreme Court level. When I see things happen on the so-called shadow docket, I know that district court judges want to do what you just said. That is, at least everyone I've practiced in front of, they want to stay committed to the rule of law as defined by precedent and by the Constitution that was written that we're trying to hold on to. You're in a position where you're at the level of judgeship that if a district court judge misses the step, you're the one that tells them, hey, go back and try this again, or go back and think about this and do this again. Do you feel like we're not getting guidance from above, not from you, but from the Supremes looking back?
No, so much of what we do is governed by precedent, but a lot of times when we're dealing with new issues, or at least new wrinkles on issues, and right, you referenced the shadow docket, what I would probably call the emergency docket. When we've got when we have an administration like the current presidential administration, and even the one immediately before it, with each succeeding administration, it seems fewer laws are being passed by Congress and more is being done through executive order. And you could say that more is done through executive order in the George W. Bush administration than had been done in the Bill Clinton administration, and more was done under President Obama than under Bush, and more was done under the first President Trump than President Obama, and you could probably say more was done under President Biden, and now we have even more being done under the second term of President Trump. And as a result of that, a lot of novel issues are being in many ways forum shopped in district courts around the country. The people who want to challenge those orders and challenge the administration's policies go to courts that they think they view as favorable to their interest. And it has huge ramifications. And then whoever the winning and losing lawyers are, they're then taking those cases to the next level of court review, ultimately to the Supreme Court. This isn't a new phenomenon to seek emergency relief in the Supreme Court of the United States and ask the Supreme Court to maintain the status quo while a lot of very difficult, hotly contested, particularly intensely political issues are being litigated in courts around the country. We've got probably more kinds of lawsuits challenging executive policies than maybe we've ever had in this in our history, and not surprisingly, at least a couple of dozen of those this year out of hundreds, but really a couple of dozen out of hundreds have reached the Supreme Court with a request as an emergency matter to maintain the status quo because, the party who's brought that to the Supreme Court says there's a high likelihood of success that, or a high likelihood that this is wrong. And the Solicitor General of the United States is the one who gets to make that decision. He's had lots and lots of injunctions entered against the administration, and he's picking and choosing which of those to take ultimately to the Supreme Court and seek emergency relief for. He's not taking them all, Tommy. Keep that in mind. He's taking the ones that he thinks he has the best chance with, and he's a really good lawyer. He clerked for Justice Scalia. Don't be surprised if he chose pretty well. He doesn't win them all, but he wins a lot of them. But you gotta consider that in context. You gotta consider how many of those kinds of lawsuits there are, how many injunctions have been entered, and then this is really a subset of those. And even then, even though he's won a lot of those and obtained emergency relief in a lot of those to maintain the status quo while these cases get litigated, he hasn't won them all.
Well, what I see, and I think it's consistent with what you just said, is the Supreme Court may set aside the injunction, but never reach the merits of what the case is about underneath the injunction.
Well, what they're doing is maintaining the status quo while the case gets litigated, while the record gets developed, while the various courts around the country issue their rulings. It will eventually get back to the Supreme Court for a more definitive resolution and for the guidance that you're talking about. But in the meantime, there's at least a handful of these where the Solicitor General thinks, hey, I've got a really good argument that this ruling is not likely to survive further review. And for that reason, the court should give me the emergency relief of maintaining the status quo while we still sort these things out. And it may be that in the end, he'll be wrong about that. And the court will think that, in fact, what the original injunction that it stayed should have been entered, or at least some form of it should have been entered. But I would say, instead of saying that we're not getting guidance from the Supreme Court, what we're really getting is lawyers asking the Supreme Court more often than ever before, because the kinds of litigation that's being filed is different from ever before, to grant them that kind of emergency relief. My court, at the Court of Appeals, we get requests for emergency relief all the time. We immigrants who are being deported from the country come and ask for a stay of deportation, or stay of removal is what we call it these days. Or if there's about to be a death sentence carried out, an execution in one of our states, very often lawyers come on the eve of the execution asking us for a stay of execution. Some of that kind of litigation reaches the Supreme Court too, and has reached the Supreme Court, but this highly charged litigation that has come about because of lots and lots of very aggressive executive orders have changed the game, and now the Supreme Court has more of that kind of emergency request for relief than ever before. But the Supreme Court's not the one generating it. The lawyers who have these cases are the ones asking the Supreme Court to grant them the relief. There are just more motions for emergency relief than there have ever been.
You know, taking that a step back, I interviewed Doug Jones and asked him a few questions about the atmosphere of the Congress, both the House side and the Senate side, in this day and age versus when he was there. And I just thought of this, so the brain is still working. But the reason, possibly, that we're having more and more executive orders is because what Doug shared with me is that the congressmen nor the senators, they're certainly not talking across the aisle to each other. And they're not even talking within their own respective parties very much to each other. And so you're left with stagnant, no action taking place in Washington, which leaves the executive order the only recourse to get something accomplished. Just thinking that through. That makes sense to me of why we would have more and more executive orders.
Yeah, I mean, but keep in mind, President Obama, when he had a Republican Congress to deal with, said that he had a phone and a pen. he was entering more executive orders than, I think probably any previous president had. And that problem, I mean, we've got a House of Representatives what's the margin in the House right now? It's super close. I mean, it wasn't long ago that we went through how many speakers of the House because the majority couldn't agree on who should be the speaker. We, kept changing who the speaker was. And so it's difficult in the polarized political landscape that we have now for Congress to achieve major legislation, to agree on major policies, and as a result, we're more likely to see policy making through the executive branch. That's what we've been seeing with every succeeding generation, and then that, of course, has an effect on what we in the courts see on our docket, and what ultimately the Supreme Court sees on its docket. But we're the reactive branch.
Right.
We don't generate any of this.
No.
It's only what is brought to us.
But it's originating by the lack of action amongst Congress, to me.
Yeah, I think there's a lot of truth to that.
Because it's putting lawyers in a position. It's putting the leader in a position to do something. And if he does anything, at least 50% of what he does, people are not going to like. And they're going to file a lawsuit and ask for an injunction at the district court level. And sometimes they're granted and sometimes they're not. But then they go up to the Supreme Court, who may lift the injunction and never reach the merits of the underlying basis of why the executive order was issued and why the lawsuit was filed to begin with.
But what's more likely happens is that the Supreme Court stays the injunction while the case continues to be litigated. I don't think we've really seen the court vacate the injunctions. Now, in the case of the universal injunction issue that they actually took briefing on and issued a ruling that does give us guidance earlier this year. Even there, what they did was they sent the case back to the district court. They vacated, I think, the universal injunction, but then sent it back to the district court to consider, based on the opinion that they issue, what kind of injunction would be appropriate. I don't think it's fair to say the court's just stopping the litigation. I don't think that's what's happening. The court's sometimes granting emergency relief in this subset of cases the Solicitor General brings to its attention. But those cases continue to be litigated and will later result in more definitive rulings.
Well, I tell you, I would feel a bit lost if I were a district court federal judge trying to adhere to their oath, as you've talked about, with uncertainty of how it would be received if it goes up a level.
Well, you know what the district
that's
judge,
a tough job.
Judge friends tell me?
Well,
my district judge friends always say to me, now, after I finish with it, just make sure that if you're going to reverse, you reverse and render. I mean,
for those that don't know what that means they don't have to hear it again.
That's right. If you're going to reverse me and you say I got it wrong, then definitively resolve it the other way. But what the district judges are really saying is, look, I know I'm not the last stop. I know that I've got to do the best with what I have here. But you have to be also humble enough to know that the way the system works is you weren't meant to be the final word. That's true for us on the Court of Appeals, too. I mean, it's, the district judges have always had their homework graded by us on the Court of Appeals routinely. Virtually any of their cases may get reviewed, but except for guilty pleas and things like that. But a very small percentage of our cases at the Court of Appeals then get reviewed by the Supreme Court. Even then, we know we're not the last word. That potential is always there, and I think we want it to be that way. I think district judges do, as you said earlier. They give it their best. They try to figure out what the precedents require. They try to assemble, the evidence in a way that gives all parties an opportunity to be heard. But they're not the last word, and sometimes the precedents have to be reconsidered. You can only do that at the Supreme Court or at the Court of Appeals, and even there, you're going to have multiple judges look at it. It's not going to be, the district judge has a lot of power in a lot of ways as a single judge deciding a case, entering that first ruling. But there are a lot of reasons why, as a matter of checks and balances, we want a lot of other judges to oversee that process and review that process to make sure we get it right.
So your position would be that the rule of law is intact and is functioning as best it can in today's political climate.
Yeah, I think that's right. I mean, look, I think our branch is as strong as it's ever been and as independent as it has ever been. You think about the challenges sometimes the judiciary faces, and I think we have a tendency or temptation to think that we're going through some period that is uniquely challenging. But look back at when the Jeffersonians came to power, when Thomas Jefferson was elected and Congress canceled terms of the Supreme Court of the United States. there was an impeachment of the Supreme Court justice. Now, he was acquitted in the Senate, but he was impeached because House members didn't like how he was doing his job as a judge. And there are a lot of reasons to think that we enjoy a lot more independence and respect now than the court did then. The court was in a much more precarious and fragile position. That's not to say we don't face challenges. We face challenges, that we always do, and it's incumbent upon us to safeguard our independence by being as transparent as we can be and remaining focused on the rule of law. And allow the public to read our opinions and see the job that we're doing. Understand that not, whatever the press may say about us, everyone can now inspect our opinions on our court websites and read them for themselves and see what the arguments are actually about. And I think when you see how we actually perform our work, you see that, for example, at the Court of Appeals level, our judges agree, regardless of which party, of the president it was that led to the appointment of the judges on a particular panel. Our judges agree in more than 90% of our appeals unanimously about what the law requires in any given appeal. And I think that's a real testament to the rule of law. If you actually see the percentage of cases that the Supreme Court decides unanimously, and then how the lineups are very different where the court is divided, I think all of that is a testament to the rule of law. It's a challenging period. It's always been a challenging period in our history. We've got to work to safeguard the rule of law. But I would say, yes, the rule of law is still working.
Well, as we close this episode, I am coming away from this conversation with much more optimism than I went into it with. And I want to thank you for enlightening me and our listening audience on those things that you've shared with us. Do you have anything to say in closing that you'd like to impart to us? It's good to know the rule of law is still intact.
Well, I'm hesitant to say anything that makes you feel anything different from where I've left you. If you're feeling better right now, Tommy, I want to keep you there.
Well, it's not just me. There's somebody in South Africa listening, and there's somebody in Australia listening. So I appreciate you taking the time today to be with me, and I really know that's burdensome because I know you have a heavy caseload. I do know that you've been surrounding yourself with law clerks today to get some help, helping you streamline what you ultimately have to sign your name to. But I just really appreciate you reaching out to me and taking the time to be with me.
I'm happy to do it, Tommy, and I'm happy to say to your listeners that I've really admired your work over the years. I think your calling is to be a defense lawyer, Tommy. I think you found your calling.
I think it found me.
Well, and I'm grateful that you do it.
Thank you.
We need great defense lawyers, and it's been a pleasure talking with you.
Thank you for joining me today on The Real Truth. My name is Tommy Spina. I hope you enjoyed today's conversation. I hope you will follow or subscribe to my podcast and listen in to the next episode. If you found it valuable, please take a moment to rate it and review it. It helps us to reach more listeners that care about the issues that matter. Share it with a friend. Stay engaged and remember, the truth matters. I'll see you next time.